Hello, you're watching Addleshaw Goddard's Employment Channel. Following a short break in programming, we're now pleased to bring you the first of two special roundup programmes, summarising the most important developments from the past couple of months. In today's news programme, we recap the key points from two Supreme Court decisions on age discrimination. We'll also look at a Court of Appeal case which examined whether an employer was entitled to withhold a contractual payment in lieu after discovering that an employee had committed gross misconduct. Finally, a more recent European case on whether annual leave that coincides with sickness can be taken at a later date. In our first age discrimination case today, in Selden, the Supreme Court looked at the scope for justifying direct age discrimination. Mr. Selden was a partner in a solicitor's firm until he was forced to retire at 65 under the terms of the firm's partnership deed. The firm accepted that this amounted to direct age discrimination, but argued that it could be justified as a proportionate means of achieving a legitimate aim. The Employment Tribunal agreed, holding that the mandatory age of 65 was a proportionate means of achieving three legitimate aims: staff retention, workforce planning, and dignity. The Supreme Court also held that the law firm had identified legitimate aims which could potentially justify its compulsory retirement of a partner at 65. However, the court acknowledged that the test for justifying direct age discrimination is different to the general test for justifying indirect discrimination. For direct age discrimination, the legitimate aims must be based on social policy objectives, such as employment policy, the labour market, or vocational training. The European courts have identified two legitimate aims along these lines: intergenerational fairness and dignity. In this case, the law firm's aims of staff retention and workforce planning related to intergenerational fairness, and its third stated aim was dignity. The court confirmed that a legitimate aim still has to be legitimate in the circumstances, and the means of achieving the aim must also be proportionate and necessary. Overall, the court was satisfied in that the aims identified in Selden amounted to social policy objectives, but the case was sent back to the Employment Tribunal to consider whether the firm's chosen retirement age of 65 was a proportionate means of achieving the legitimate aims identified. Kerry Hughes, a managing associate in our employment group, comments on what this case means for employers.
The Supreme Court's decision probably now makes it more difficult for organisations to justify a mandatory retirement age. Employers first need to show that their legitimate aim is of a public interest nature, rather than purely private aims, such as reducing costs or improving competitiveness. This should be easy enough, since most good employers will still strive to operate with the types of social policy aims identified in Selden, including fairly sharing work and opportunities between different generations, and avoiding undignified performance management of older employees. However, whilst the court accepted that dignity could be a legitimate aim, they did express concern that stereotypical assumptions about capabilities at a certain age might be used to set retirement age for all of that age. This is a warning to employers not to jump to conclusions about what employees of different ages can and can't do. It might be more difficult for employers to show that the aims are actually legitimate in the circumstances of the business. For example, employers can't rely on an aim based on helping to recruit younger workers if, in fact, there's no problem in recruiting younger workers. Similarly, avoiding the need to performance manage one section of the workforce may not be a legitimate aim if an employer already has a sophisticated performance management measure in place. Basically, employers will have to provide evidence to support a particular approach, and should also keep any mandatory retirement age under review to ensure that their original aims remain legitimate. Finally, employers need to show that the retirement age is proportionate in the circumstances of the business. This involves proving that the particular retirement age chosen, say 65 as in Selden, was an appropriate and necessary age as opposed to any other age such as 67 or 70. As workforce demographics change and employees are capable of working longer and want to do so, employers will have to keep any retirement age under review for it to be justified. This aspect of the Selden case has yet to be decided by the Employment Tribunal, so we await the judgment with interest.
In Homer, the Supreme Court considered the scope of indirect age discrimination. Mr. Homer started working for the police as a legal advisor when he was 51. He didn't have a law degree, not least because when he was appointed, this wasn't a requirement of the role, and he had other qualifications and skills or experience in criminal law instead. A few years later, the police introduced a new career structure, which included a requirement that to reach the top grade as a legal advisor, employees had to have a law degree. Mr. Homer, who was 62 by the time this requirement came in, didn't have a law degree or even time to obtain one before he reached the police's retirement age of 65. He wasn't appointed to the top grade. Mr. Homer brought a claim for indirect age discrimination under the old age regulations, which have now been replaced by the Equality Act. The Employment Tribunal found in his favour. He successfully argued that the requirement to have a law degree for appointment to the top grade amounted to indirect age discrimination, since because of his age, he wasn't able to obtain a law degree before he reached retirement age. He also successfully argued that this discrimination wasn't justified. However, the EAT and Court of Appeal both found that it wasn't Mr. Homer's age which put him at a particular disadvantage, but actually his impending retirement, and that his position could be compared with employees of any age group who are nearing the end of their employment for whatever reason. The Supreme Court disagreed, finding that employees in Mr. Homer's position were disadvantaged because of a reason, retirement, that directly related to their age, and that it couldn't be right to equate leaving because of impending retirement with other reasons for leaving, because a person coming up to a mandatory retirement age doesn't have a choice in the matter. Although Mr. Homer was indirectly discriminated against on grounds of his age, it's still open for his employer to seek to justify the discriminatory requirement. That issue has been sent back to the Employment Tribunal for consideration in light of the Supreme Court's findings. Again, Kerry Hughes comments on some of the more interesting aspects of this decision.
It's quite striking that the Supreme Court was willing to treat factors related to age, in this case retirement, as being part of age, so that treating a person in a certain way because they're about to retire is the same as treating a person on grounds of age. It'll be interesting to see whether other stereotypical traits can be relied upon as related to age. This decision makes it clear that it's quite a low threshold for a claimant to establish indirect age discrimination. This could mean that employment tribunals are more likely to resist employers' arguments that the definition of indirect discrimination hasn't been met, particularly where the claimant can show broadly that people in their age group are disadvantaged compared to other age groups. If that's right, the main battleground will be justification for the relevant provision, criterion or practice. It'll be interesting to see how the Employment Tribunal determines this issue in Homer.
Moving on now to issues that can arise upon termination of employment. In this case, the employer decided Mr. Kavanagh was redundant and summarily terminated his service agreement, which provided for 6 months of pay in lieu of notice. Later, though, the employer discovered that Mr. Kavanagh had committed gross misconduct before the termination of his employment. The employer decided not to make the payment in lieu to Mr. Kavanagh on the basis that had it known about his gross misconduct when exercising its contractual power, it would have treated his gross misconduct as a repudiatory breach of contract by Mr. Kavanagh and considered itself discharged from any obligation to make payment. However, the Court of Appeal held that Mr. Kavanagh had acquired a right to the payment. Unlike wrongful dismissal, employers can't rely on after-the-event knowledge about gross misconduct where they have already chosen to lawfully terminate under a payment in lieu of notice clause. This is because their actions have already given rise to a debt. Here, there wasn't a provision in the contract releasing the employer from that debt in these circumstances. Again, Kerry Hughes gives some valuable guidance for employers.
There are steps that employers can take to mitigate the effects of this case. The first is to include a provision when drafting a payment in lieu of notice or pile-on that enables the employer to recover or avoid paying the pile-on should any earlier repudiatory breach by the employee later come to light. Secondly, where a compromise agreement is used on termination, as they often are, especially with senior employees, it can be a condition of the agreement that the employee confirms that he or she hadn't committed any repudiatory breach of contract. Although not considered in this case, employers should also be aware of similar situations that may arise with post-termination rights to exercise options or receive long-term incentive plan award shares or to receive cash bonuses in respect of performance periods ending after termination. Again, it would be sensible to review the terms of these schemes to check that any payments made are always conditional upon or subject to an employee not having committed a repudiatory breach of contract.
Thanks, Kerry. Finally, the European Court of Justice has recently ruled that workers who fall sick during their annual leave are entitled to take corresponding paid leave at a later date. It was already clear from previous case law that workers who became unfit for work before a period of statutory annual leave must be able to take that leave at a later date. So the point when a worker becomes unfit for work is actually irrelevant. The ECJ said it would be contrary to the purpose of the Working Time Directive to allow workers to postpone their annual leave only if they were unfit for work at the start of the annual leave. This case therefore serves as a handy reminder to check that your sickness absence policy deals with the situation where an employee falls ill on holiday. The policy should make clear what steps an employee has to take to report themselves as sick. For sickness that falls during holidays, employers could, for example, require employees to provide medical evidence of their ill health. This will help employers challenge any suspicious requests to reschedule annual leave in these circumstances. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.